Your Lordship, 2 weeks may be granted to me for filing my affidavit. 2 weeks may be granted for me to file my affidavit. Item 11,
Yes, what is a prayer?
2 weeks for filing my affidavit, Your Lordship.
Or affidavit?
Yes, Your Lordship.
Ms. So the learned counsel appearing for the respondent state, right?
Yeah, for the state use.
Respondent state submits that says as prays for 2 weeks time to file the affidavit in opposition. In the instant case, prayer is allowed. Let the matter be listed after 2 weeks.
Lordship is an interim. Kindly let him continue.
Okay, Mr. So is present for the petitioner. Interim order so passed earlier shall continue till the next date of list.
Much obliged.
May it please Lordship. Lordship, may I mention item number 2? Lordship, here the conducting counsels are from Gauhati and had a personal difficulties today. If this matter may kindly refix on 14/8, this Friday, Lordship.
Okay, on the prayer of the learned counsel appearing for the petitioner, let the matter be listed. Let the matter be listed when?
14. This
Let the
Friday,
matter be
14th.
listed on 14th.
Obliged, Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention hearing item number 24, Lordship. Lordship, I've taken the consent of the parties, so let the matter become up after 1 week, Lordship.
After a week,
Yes.
item number
24, Lordship.
24. The learned counsel appearing for the petitioner submits that say he has already taken the consent from the other side and prays for
Lordship, 23, item number 24, Lordship. Yes, 24.
prays for listing of the matter after a week. Prayer is allowed. Let the matter be listed after a week. After a week. Yes.
Lordship, I also like to beg to mention item number 23, Lordship.
22.
23, Lordship. Lordship, I have one urgent matter in court one, so let the matter be taken up after break,
Let
Lordship.
the matter be listed after
Break, after the lunch break.
today.
Yes, Lordship.
Not today. Today it will be difficult. Let it be after the week.
Lordship, then on Tuesday, Lordship.
Let it be listed on Tuesday, next Tuesday.
Much obliged.
May I please, Your Lordship? I'd like to mention item number 7. Here, this matter is covered by criminal petition 3 of 2026, which is listed even today in principal seat also. So let this matter be come up after the disposal of this review petition. Lordship.
This is not review petition.
No, this item number 7, this matter is similar to the review petition that we have filed in WS 6 and 7 of 2025.
Okay, Mr. So-and-so, the learned counsel appearing for the petitioner submits that the issue involving in the instant case is also under consideration in a review petition, that is so-and-so.
Review petition 3 of 2026.
3 of so-and-so. Before the
After the disposal of the review petition.
before where? Which court?
Before the division bench, Your Lordship.
Before the division bench, suppose. Therefore, he prays that the matter should be listed after a disposal of the opposite review petition. Full stop. Let the matter be listed after 4 weeks.
After the review petition is disposed of, Your Lordship.
4 weeks is, let's say 4 weeks. We are giving 4 weeks time. If it is disposed of, then you mentioned the matter.
Okay.
Lordship.
But we'll see what happens after 4 weeks. Let it be listed after 4 weeks.
Duly obliged, my lord.
Please, my lord. Your Lordship, I beg to mention item number 8.
Yes.
I have received the reply this morning, Your Lordship, and therefore the pleadings are completed. If the matter can be listed after 2 weeks, Your Lordship, for hearing.
Okay. The parties are duly represented. Joint prayer has been made that the matter may be listed for hearing after 3 weeks. After 3 weeks, since the pleadings in the matter, after 3 weeks for hearing, since the pleadings in the matter has already been completed. After 3
Lordship,
weeks.
there is an interim. Lordship.
Interim order so passed earlier shall continue till the next date of list.
Much
Duly
obliged.
obliged.
May it please Your Lordship? Your Lordship,
My lord,
Your Lordship, I beg to mention item number 17 on behalf of Muhammad Ali. Your Lordship, due to the ongoing flood situation in Assam, his train has been cancelled. So,
Who is this Muhammad Ali? His name is not there in the cause list. Is he there in the matter?
yes, Your Lordship, he is the leading counsel. He has signed the Wakalatnama.
Okay.
But here they have filed an IA for implement of the cybercrime lawsuit. Now, the IA has been filed after I filed my affidavit. I raised objection on the manageability or non-jurisdiction of necessary parties because lawsuit, the matter relates to cyber fraud. And-
Okay, let it, because he's saying that the council is not there. Let the council come, then next day we can point out those issues.
Lord.
Mr. So-and-so, learned counsel preparing for the applicant submits that the conducting counsel in the instant case could not be present in the court today. Therefore, praise for the listing of the matter on.
Next week, your lordship, on a fixed date.
Listing of the matter in the next week. Also.
And Lord,
His prayer is not objected by the learned counsel appearing for the state.
Lord, no, I'm for the bank, Axis Bank.
Mr. So-and-so for the respondent bank. Full stop. Let the matter be listed after a week.
Your lordship, kindly fix a date for this
So let
matter.
it be listed
10th,
on
Lord, Monday.
10th. Okay, 10th. Yes,
But-
10th.
Much obliged.
My lord, if I may, my lord,
Yes.
I'd like to mention item number 13.
Hmm.
My lord, here an additional affidavit was filed by the petitioner on the last date in which certain new facts and developments have been brought. So we would like to file a reply to the same.
The power grid proportion I mean the tower thing.
That is no, my lord, that's item 5.
Oh, that's
That
a
is-
different matter. Okay.
This is
Okay.
item 13, power grid.
So you want to file an objection to that?
My lord, we would like to file a reply to the additional affidavit filed by them.
Okay. You are Mr. Khera, right?
My lord.
Mr. Khera, the learned counsel appearing for the Power Grid Corporation of India submits that the petitioner has filed an additional affidavit in the instant case and he desires to file a reply to the aforesaid affidavit, additional affidavit. He prays for how much time?
My lord, 3 weeks may be granted to us.
He prays for 3 weeks time. Time is allowed. Let the matter be listed after 3 weeks. Yes.
Please, Lordship. My lord, I beg to mention item number 14. I've
14?
taken, yes, my lord, I've taken consent from the petitioner.
Hmm.
Kindly list the matter after 1 week.
Learned counsel, Mr. So-and-so appearing for
State respondent.
state respondent. Prays for adjournment of the matter. He submits that he has already taken consent from the council appearing for the petition. Full stop. Let the matter be listed when
After 1 week, my lord.
after 1 week.
Yes.
Mr. So-and-so is present for the petitioner.
Much obliged. And my lord,
My presence may also be reflected.
Okay, you,
Appearing for respondent.
Ms. So-and-so appears for responsibility.
my lord, again, I beg to mention item number 15. My lord, here I'm yet to receive instruction. So kindly.
You are appearing as what?
State, for the state.
State is there.
Yes.
Okay, Mr. So-and-so, the learned counsel appearing for the state respondent, submits that he is yet to receive the instructions in the matter to file the affidavit in opposition. Full stop. Mr. So-and-so is present for the petitioner. He doesn't have any objection to the aforesaid prayer. Let the matter be listed after 2 weeks.
Yes. 3 weeks, my lord. After 3 weeks.
After 3 weeks.
And my lord, in item number 16, state has already filed affidavit. However, this should be listed along with the item number 15.
16 is already with this matter. 16 what
Yes.
has happened?
Already filed affidavit. So,
You have filed the affidavit.
yes, my lord, the matter may be listed along with 15.
No, there's already there.
Yes.
Item number 16, you write that affidavit. You are going to file any reply?
No, your lordship. Lordship, actually, in item number 16, there is a communication by the Assam Rifles to the Deputy Commissioner to assess and calculate the actual amount of compensation and
But that is what you have brought by
Yeah,
affidavit.
already filed.
Huh?
no, lordship. The details are not given, lordship.
So, my lord, in item number 16, affidavit is already filed.
Affidavit is already filed. What he's saying is that you can file a reply to that.
Lordship.
You file a reply then.
Lordship, there is a direction by this honorable court on,
You are for the petitioner, right?
yes, lordship.
So if you have any, issues with the affidavit, then you can file a reply to
Lordship,
that. And then you can bring in those materials which are there with you
lordship.
by way of an affidavit in reply if he hasn't submitted. Okay. So we'll list it on the same date after 3 weeks.
Yes, my lord.
The item number 16, you write that the learned counsel appearing for the petitioner submits that he has received the affidavit in opposition filed by the state respondent and he wishes to file a reply to the same. Full stop. Let the matter be listed along with WPC number 104/2026 after 3 weeks.
Much
Obliged.
Yes.
Please, Your Lordship, I beg to mention item number 20 on behalf
Item
of
number 20.
Lordship, on
Yes.
behalf of H. Mukam,
Hmm?
on behalf of H. Mukam.
H. Mukam. What happened?
Lordship, the leading counsel is indisposed, so can this matter be listed after 2 weeks?
Why he is not there?
He's indisposed.
Hmm?
He's indisposed.
Indisposed for what? He disappeared somewhere. What happened? He's not well?
today. Yes,
He has some personal problem. What?
he's not well today.
Okay, MS so-and-so, the learned counsel, appearing on behalf of H. Mukam, submits that Mr. Mukam is indisposed and therefore prays for adjournment of the matter and to be listed after
2 weeks.
After 2 weeks. Let the matter be listed after 2 weeks.
Lordship, I'm responding for 4.
MS so-and-so is present for respondent of 4 and listed for
For the state.
the state respondent present. Okay.
Please, Lordship. May I please, Your Lordship?
Hmm.
I beg to mention item number 12.
12.
12,
Ye-
Lordship.
Yes.
I for the respondent number 2, 3, and 4, Lordship.
Private respondent,
State, Lordship.
state.
Standing counsel for respondent 2, 3, and 4.
Okay.
Lordship, I have received the instruction.
You want to file an affidavit?
Affidavit, Lordship, in
Okay.
opposition.
Ms. So-and-so is present for the petitioner. The learned state counsel appearing,
Standing counsel.
learned standing counsel appearing for respondent numbers
2, 3, and 4.
2, 3, and 4 submits that she has received the instructions and prays for 2 weeks time to file an affidavit in the instant case. Prayer is allowed. Let the matter be listed after 2 weeks.
Obliged, Lordship.
Wait, please, Your Lordship. I
Yes.
can mention item number 22.
Item number
22.
22. Yes.
The leading counsel is indisposed to me
Who is leading counsel?
or Muajamir.
Huh? Who is the leading counsel?
Muajamir. I'm for respondent 5 and 7.
Respondent 5 and 7.
Yes, Your Lordship.
State counsel, state, no,
Right.
private.
Right. If Your Lordship may fix this matter on 11 of this month.
He's there. No, you are there in the matter. So you want an adjournment in item number 22? 22, you are not there.
I'm there. I'm there.
So
I'm for the state.
you're you're seeking adjournment on whose behalf?
Correspondent 5 and 7.
5 and 7, who's appearing?
Muajamir.
More Jamil.
Yes, Your Lordship.
Okay. Okay, Mr. So-and-so, the learned counsel appearing for respondent number
5 and 7.
5 and 7 submits that Mr. M. Jamil, the learned counsel, learned state counsel,
Private.
private counsel, learned counsel appearing, conducting the instant case has some personal difficulties today. Therefore, prays for the matter to be listed on 11th August. Huh?
Chief, I'm preparing for respond number 6.
Wait a minute.
My lord, may have some difficulty next week. So can you wait the week after that?
The UK agree on a date? When?
Can it be on the 17th then?
17th, yes, says, yeah, if you both of you agree, then 17th be fine. We'll list it on 17th. Mr. Mo M. Chen.
Yes.
M. Chen is present for the petitioner,
State responsible.
for the state respondent, and MS so-and-so
Ayala Imjin for the petitioner.
is present for the petitioner. And please mention her name also here for
Respond number 6.
respondent number 6.
Yes.
Your Lordship, I also like to mention item number 10. If Your Lordship may kindly allow 3 weeks time to file my affidavit in opposition.
Affidavit in
Reply.
reply. You have filed an affidavit. Okay, Mr. So-and-so, the learned counsel. Your name?
Keshicho.
K.
Keshicho.
Keshito.
Yes,
Keshijo.
Your Lordship.
Keshijo, the learned counsel, appearing for the petitioner, submits that he has received the affidavit in opposition filed by the state respondent and prays for 2 weeks time to file reply to the aforesaid. Full stop. His prayer is allowed. Let the matter be listed after 2 weeks.
Lordship.
MS so-and-so is present for the state.
May I please, Your Lordship?
I beg to mention item number 4, Lordship.
Item number
4, Lordship. Lordship, my senior has some personal difficulties today, Lordship.
Hmm?
So my senior has some personal difficulties
who is
today,
the
Lordship.
senior?
Sandy Younger, Lordship.
Okay.
Counsel for the petition. So I pray that let the matter be released after a week.
Okay, Mr. So-and-so, the learned counsel appearing on behalf of Mr. Sentianger submits that Mr. Sentianger has some personal difficulties today and prays for the matter to be adjourned and to be listed on
After a week, Lordship.
listed after a week. MS so-and-so, the learned counsel appearing for the state doesn't have any objection. Let the matter be listed after a week.
Lordship, there is an interim.
Interim order so passed earlier shall continue till the next date of listing.
Lordship, similar prayer for item number 6 as well. Item number 6,
6,
Lordship.
6, you were there.
Yes.
Just mark their presence and the same prayer. Mr. Sentianger.
Oblige you.
May I please, Your Lordship? Lordship, I beg to mention item number 9.
9.
Lordship,
Yes.
on behalf of Ace Chang.
On behalf of
Ace Chang,
H. Chang is who?
a state for the state. Lordship.
State.
Lordship, today shared some personal difficulties, so if this matter will come up after 2 weeks.
2 weeks. MS so-and-so is present for the petitioner. MS so-and-so, the learned counsel appearing on behalf of H. Chang.
Ace Chang.
H. Chang, the learned government advocate, submits that the MS Chang is in this Chang is not present today in the court and therefore prays for listing of the matter when
After 2 weeks.
after 2 weeks a prayer is not opposed by the learned counsel appearing for the petitioner. Let the matter be listed after a week.
Oblige, Lordship.
Lordship, I also like to mention item number 21. On behalf of additional AG in the song. Lordship, on the joint prayer, can you list this matter on 20 of this month?
Okay, MS so-and-so, the learned government advocate submits that government advocate appearing for respondent number
1.
Respondent number 1 submits that additional advocate General Nagaland is conducting the incident case and he is not there in the court.
Lordship, you have some personal difficulties, Lordship.
He has some personal difficulties today and therefore prays for listing of the matter after a week.
Lordship, on 20 August.
Prays for listing of the matter on 20th. His prayer or her prayer is not opposed by the counsel appearing for the petitioners, namely so and so. Let the matter be listed on 20th.
I pledge.
Promotion, item number 1.
May I please, Lordship? The petitioner is aggrieved by the findings of the disseminated authority by which the petitioner was imposed a major penalty of reduction to lower stage in the timescale pay by 3 stages for a period of 3 years and no increment, my lord. The inquiry, the findings was based on no evidence and the petitioner, the findings was preserved, my lord. I may take your lordship to some relevant documents, my lord.
But you are aggrieved by what?
If
Aggrieved by your
impugn order dated 2011-2024,
page,
by
page,
which
page.
page number 115, my lord, annexure M.
115.
Yes, my lord.
15.
Yes, 115. The penalty order is at page number 116, the next page. This is the communication letter.
1 second.
Yes, my lord.
Have you filed any appeal?
Yes, my lord. I filed an appeal before the appellate authority. That was turned down. Thereafter, I filed a review before the review commission. That was also turned down. On the same line, and then being a brief, having the alternative remedy, I'm before this honorable court, my lord.
What is the problem with the order?
My lord, here, 3 allegations were framed against the petitioner, my lord. The first allegation was not proved. The second allegation was partially proved. And the third allegation, which was based on the second allegation, was deemed to be proved, my lord. And based on those findings, though there was no evidence that the allegations were proved against the petitioner. So, my lord, in order to substantiate, my lord, I may take your lordship to the documents, my lord. Annexure B, my lord, page number 37.
Annexure
B, page 37, my lord. This is the order by which the petitioner was placed under suspension, my lord. Page number 37, my lord. I will just take you to some relevant documents only, my lord, not the whole documents, since the petition is upheld here. By this order 24/5/2023, my lord, the petitioner was, while serving as branch manager, SBI Chisama branch, he was placed under suspension.
Yes.
And then the next page, page number 38, these are the allegations which were leveled against the petitioner, my lord.
Yes.
Private and commercial to so-and-so, sir, so-and-so. It is observed that while discharging your duties as branch manager at State Bank of India, Chisama branch, you have committed the following irregularities violating the State Bank of India officers service rules. It is reported that you have consumed wine, beer in the PM chamber. The IO has found 3 wine bottles kept in your drawer. In a video footage dated so-and-so, a highly irregular aspect is observed in absence of you at the branch. One outsourced staff named Zulhi Chira found sitting on the PM's chair and using your CPS ID and fake fingerprints to pass the check by imitating your signature. C. Outsourced staff does various CPS activities using your login credentials, which are to be kept secret as per instructions in absence of you, such as SOD, EOD, cash issue and receipt to and from so-and-so. Number D. 2 outsourced staffs are sanctioned for Chisami branch, but most of the days, only 1 staff.
Okay, these are allegations then?
Yes, this was the allegations. Now, hereafter, my lord, the petitioner was asked to file an appeal, if so advised, within 45 days, to which he has filed the appeal. The representation is page number 41.
One second.
Page 41, Annexure C. This is his representation, denying the allegations.
There was no so-called notice issued before the suspension.
My lord?
Before the suspension, there was no so-called notice issued.
No so-cause.
Okay. Then
Thereafter, my lord, the petitioner has submitted his representation.
then this order was passed.
Yes.
Page 40?
Yes, page 41. Yes. After the page 40 was issued. 41 is the appeal against my suspension order, which the petitioners replied on 21/6. Thereafter, my lord, page number 44. Here, page dated 22/11/2023. A disciplinary proceeding was proposed to be initiated against the petitioner.
Yes.
Lapse on 2 lapses. First lapse is you used to drink alcohol and other prohibited materials during office hours, and those were kept in your PM cabin. During the investigation, 3 bottles of wine were found in the lower drawer of your official table. Lapse number 2. During official hours, you compromised your CPS credentials with one of the branch outsourced person and allowed him to authorize branch transaction in your CPS system. On 13/2, you entered branch at 10:01 a.m. and went out at 10:20 a.m. During the said time period, the outsourced person, so-and-so, was seen sitting on a chair and open CPS system. Then he went on passing the check in the system and put his signature on the vouchers. In view of the above, you are grossly negligent in discharging your duties.
Yes.
Of
Then
so-and-so.
what happened?
Thereafter, the petitioner have replied to the
Allegations.
Yes, the next is at page number
Yes.
45. Thereafter, my lord, page number 44 is the charges framed against the petitioner.
Page number
44, 47, my lord.
47.
Yes, yes, Annex F.
Hmm.
47. Dated 27/12/2023. Dear Sir, Staff Supervisor, Disciplinary Proceedings. So this is the article of annex, page 48 is the Annex 1.
Okay, you
Article
have
of charge.
given this all the charges, the
Yes,
allegations, documents, everything.
Yes, yes, my lord.
So you don't have any problem with that.
No, my lord.
You don't have any
Yes,
problem
yes.
with all documents were
Yes.
given to you.
Yes.
Video
No.
footage was given to you.
Yes, yes.
Huh? And a statement of allegations, statement
Yes.
of all these things were given.
Yes,
Then-
my lord. Now page number 52. This is important, my lord.
Hmm?
Page number 52. Annex H.
Page
52. 52.
52, yes.
This is important, my lord. Here.
Hmm.
This is a letter dated 13/6/2024.
Hmm.
Dear Sir, Developmental Inquiry, de novo, Vigilance, so and so. Please refer a letter number so and so dated 27/12/2023 relating to the article of charges and statement of allegations alleged against you while working at our office, Zizami branch during the period from 3/6/2021 to 23/5/2023. Under suspension since 24/5/2023, you replied thereto by letter number so and so. It has found unacceptable. Accordingly, development inquiry has been ordered into the imputation of lapses alleged against you, and inquiry authority, she so and so, has submitted inquiry count finding on 31/5/2024. The first inquiry, it was completed, though the inquiry report was not furnished to the petitioner in this. Number 2, my lord. Further, while revisiting the inquiry report count finding dated 31/5/2024 of the above case and examining the report in detail, it has been observed that there are infirmities in the inquiry. I therefore order an inquiry de novo and have appointed she so and so as inquiry authority in terms of rules so and so of the State Bank of India. My lord, the first inquiry was conducted. The
first inquiry was not accepted.
Yes.
Then de novo inquiry was done again.
Yes. And then the report was not given to me also, and then no reason was.
Okay, so you were not aware like what has happened there. In the
Yes.
inquiry. Then de novo inquiry happened. Then
Yeah, de novo inquiry happened.
the de novo inquiry, what are the steps they have taken?
No, the de novo inquiry is also completed, my lord. It's concluded, my lord.
Conclude. We are not. I mean, about the process of the inquiry, you don't have any problem.
Yes, my
You
lord.
don't have any grievances. Then,
No interest.
Then.
So now may I come to the findings of the inquiry committee, my lord.
Hmm.
Inquiry, page number 54.
54, yes.
Here. This is letter dated 7/4.
So one allegation, one is
Not proof.
not approved.
Yes. The allegation was that I used to drink
Then,
alcohol. Number 2 allegation is
Partially
partially
proved.
proved.
hmm.
No evidence.
So he said that it's proved. Allegation 3. Allegation number 2.
So, my lord, may I take you to the detailed findings of the inquiry report, my lord? Page
So
number-
allegation number 2 is proved, right?
No, my lord, it's partially proved.
Allegation number 3 is also proved. In view of
Allegation
the
number
court,
3
it is grossly-
is the findings
correct,
of
correct,
based on.
finding. So allegation number 2 is proved. They are saying that some transactions happened during that time.
Yes,
You were not there.
transaction, but it was not. I'll come to that, my lord. Here, my lord. This is the page of 58 is the detailed findings of the inquiry report.
Hmm.
Here, I will just take you to, my lord, the IA's finding, inquiry authorities finding, page number 74.
Yes.
Here, 3 witnesses were examined here, my lord. The right-hand side column, my lord, the last para, referring to the deposition of Shri Ashutosh Kumar, Chisama branch, prosecution witness 2, PW. During cross-examination on 27/8 by the defense representative, he deposed the inquiry that I used to remain busy in my office at the branch. I have seen sometimes the authorized person in the PM's chamber, but not seen he has passed any queue. I have not seen this kind of incident in the branch. The prosecution witness during cross-examination by DR on so-and-so deposed the inquiry that from the CCTV footage dated 13 to 2024, I have not seen Mr. Zulhechira sitting on PM's chair and executing transaction on his behalf. Again, during cross-examination dated so-and-so, the prosecution witness PW1 deposed the inquiry that he did not find the signature of so-and-so from PX and so-and-so to so. Referring to defense representative contention that all those vouchers passed from the first floor of the building where there was an alternate system set up installed in one of the rooms at the upstairs, and branch manager, in order to complete his audit compliance, preferred sitting there away from the customers to facilitate undisturbed completion of tasks. Here, the DR cited the response of Shri Ashutosh PW2, his deposition during cross-examination on so-and-so that the branch building comprises ground floor and first floor. PM chamber, 2 single window counter, customer service area, vault room, and banking hall is on the ground floor, and there are 4 number of rooms on the first floor earmarked for staff accommodation. As per the deposition, one system is also there in the first floor in one of the rooms. However, during re-examination by PO, he told the inquiry that sometimes he has seen there is a system in one of the rooms on the first floor, but he did not tell that the CSO used to work during banking hours sitting on his room on the first floor. It's just he didn't state that he has seen him working. That was a sole ground matter. Hence, from the above facts, defense representative's contention could not be accepted as there is no banking hall on the first floor. He, PW2, did not tell the inquiry that PM was doing banking transaction sitting on the first floor earmarked for staff quarter, where any system with CPS peripherals was working on or not, nothing told by the PW2. Moreover, PW1 during inquiry proceeding did not depose the inquiry that CSO was used to work from his quarter earmarked for staff accommodation on the first floor. Had it been staff as well as customers could have visited him on the first floor instead of meeting him in his PM chamber. Hence, from the above facts, DR view could not be substituted. IS view. Considering all the facts and evidence presented by the presenting officer as well as the defense representative, NEFT transaction amounting to so-and-so were passed in the system on 13/2 during absence of the CSO, and from the branch. However, passing of those preferred vouchers in CPS by the outsourced person in the absence of the branch manager could not be established. As no evidence available on the CCTV footage to substantiate the claim. However, the fact is that during CSO absence, that from the branch NEFT transactions were being authorized in CPS reflecting his ID and checker authorization on 13/2/2023. Hence, considering the above facts and circumstances evidence, allegation number 2 leveled against the CSO so-and-so, number so-and-so, stands partially proved. Why not page number 79, page number 79, if I may be allowed to read the middle column, the last spiral. So this is also relevant because they are alleging that 3 transactions were made when the petitioner was out of his office and the outsourced employee has done the transaction using his CPS system. Just to justify that, my lord. Page number 79, the last spiral. Here, the Margaret IT for the first 2 transactions has been Mr. Satvinder Singh, and checker ID is that on of Mr. So-and-so. In case of the third transaction, the marker had been Mr. Asutosh Kumar and the checker ID as so-and-so reflected as been that of Mr. Delhorako. Now, as per the allegations, all these three transactions were passed by Mr. Zulit Chira, that is the author's employee. If in NEFT transaction, the settlement cycle is generated while posting the voucher in the system, and the time of settlement cycle for the first transaction as per PS so-and-so has been 11/18/08, and the transaction was made by Satwinder Singh ID number so-and-so in NEFT transaction number so-and-so. Message is generated when the transaction is buzzed in the system, and the time of passing of the transaction had been 11:55/08, my lord. Timing. The time of passing the second NEFT transaction put through by Mr. Sadishwar at 11 so-and-so as per the PSS had been 11:58/54. As per the CCTV footage, my lord, the outsourced employee, Mr. Zulhi Chira, was seen going out of the branch at 11:43, my lord, at AM, and again entered branch at 12:11 in the afternoon. So this transaction happened when the outsourced employee was out of the office.
Now, what is you're seeking for now? You are already suspended.
I'm already suspended, and then I'm only been given the punishment of the reduction to lower stage. So against the order, I preferred an appeal, which was
Rejected. Now, what is there any interim prayer you're playing for?
No, well, I'm not able, but at this stage, I only pray that notice may be issued, and then.
Correct. Okay, heard, Mr. Your name?
N. Mukammal.
Nikomo Dalada Council appearing for the petitioner. Full stop. The instant petition under Article 226 of the Constitution of India has been filed by the petitioner impugning which is the last order review petition?
My lord, the impugn order passed in the review
10/7.
No, to 27/6/2025.
The impugn order dated 10/7/2025 is what?
My lord, 2011/2024 is the impugn order passed by the disciplinary.
Okay, impugning the order.
Yes.
Order number DMHUB/EST/NE/24-25/069 dated 20/11/2024, imposing measure penalty of reduction to lower stage in the time scale of pay by 3 stages for a period of 3 years. He has also impugned the order dated 25/3/2025, wherein his appeal was rejected by the appellate authority, as well as the impugned order dated impugned the order dated 10/7/2025, whereby his review petition was rejected. Full stop. The case of the petitioner is that petitioner was serving as a branch manager, SBI, Sijami branch, full stop. Full stop. Petitioner was put under suspension on 24/5/2023 by the authorities of SBI for allegations of misconduct. Against the order of suspension, the petitioner submitted his representation on 21/6/2023. However, the same was rejected. And vide a letter dated 2/11/2023 proposed to initiate a disciplinary proceeding against the petitioner, alleging that the petitioner used to drink alcohol during the office hours and that he compromised his CBS credentials with one outsourced employee of the branch and allowed him to authorize the branch transactions. There was also an allegation that on 13/2/2023, during the absence of the petitioner, the outsourced person was seen sitting in petitioner's chair, opened CBS system and went on passing checks in the system and signed the vouchers. Full stop. The petitioner replied to the aforesaid allegations by denying the same on 4/11/2023. Thereafter, the respondents, by letter dated 27/12/2023, decided to initiate a disciplinary proceeding of measure penalty, and after completion of the proceeding, the inquiry authority submitted its report on 31/5/2024. But after the but though the inquiry was completed by the inquiry authority, the same was not accepted, and a de novo inquiry was ordered by the order dated 13/6/2024. Accordingly, the de novo inquiry was initiated, and the inquiry authority, by its letter dated 7/10/2024, submitted its report, wherein the petitioner was found to be guilty of the first allegation, and second allegation was found to be partially proved, and third allegation proved. Full stop. Consequent upon the aforesaid findings of the inquiry authority, the disciplinary authority, by the order dated 20/11/2024, imposed the measure penalty of reduction to a lower stage in a time scale of pay by 3. But you have when was the last this thing? Your the review petition was rejected on 27/7/2025.
Yes.
What are you doing for such a
No,
long
my
time?
thereafter, well, I was
After the review rejection, what have you done?
thereafter I was taking initiative to prevent petition before to file a petition before this honorable court, and then in the meantime,
But it took so much of time. It was 27/7/2025.
no, my lord, that's why I'm not
1
praying
year.
for. Yes, that's why I'm not praying for interim order, and then my lord, the limitation period for petition filing a writ is 3 years, my lord.
But still, you were late.
Yes, that's my lord, and then
Okay.
because
Okay, right. And then disciplinary authority by order dated 20/11/2024 imposed the measure penalty of reduction to a lower stage in time scale of pay by 3 stages for a period of 3 years with no increment to pay during the period of such reduction. The petitioner preferred an appeal before the appellate authority against the aforesaid order dated 20/11/2024. However, the same was rejected by order dated 14/2/2024-25. Thereafter, the petitioner filed a review petition before the review committee, but the same was also rejected by the order dated 27/7/2025. The learned counsel, appearing for the petitioner, submits that in spite of two primary allegations being not properly not proved against him, and only the second allegation is supposedly partially proved. The petitioner has been the petitioner has been awarded with measure penalty, which is not sustainable under the law. He submits that on perusal of the inquiry report, it makes it clear that the allegation number 1 has not been proved, and allegation number 2 has said to have been partially proved, but partially proved without any cogent and reliable material before the inquiry committee. Full stop. In view of the aforesaid, he submits that the instant petition should be admitted. Full stop. Issue notice to the respondents by speed post as well as normal course within a period of 3 days, within a period of 3 days, let the matter be listed after 3 weeks.
For motion from the supplementary course list, item number 25. Item number 25.
Pass it over for time. Pass it over for time. What is that?
For motion from the supplementary course list, item number 26.
'26, you are there.
Item 25.
25. It's 25 and 26. We have code.
You are appearing in which?
For the petitioner.
Huh?
Item 25 and for the petitioner, my lord.
25?
Yes.
Yes.
Mhm.
Yes. What is your case?
So my case is that, my lord, I was initially appointed as a lecturer. I was initially appointed as a lecturer in the post of mechanical engineering.
But yours is a contract job.
Yeah, it's a
What right do
contractual.
you have? What right do you have?
Right,
They don't want your service now, so they have discontinued you.
my lord. In a democratic state,
Forget about democratic state. It is a contractual job. You have been specifically, it was mentioned it's a contract job initially appointed for 6 months. Then it was extended. Then I mean they do not want your job. They don't. Because this contract job business cannot go in and go on. They'll have to recruit people, right? They'll have to recruit people by advertising. In a democratic state, that is the state. That is the thing you need to do. So what is your right?
my lord, arbitrarily my service was discontinued. I was not even informed.
What
It
is
was-
arbitrariness?
I was hired and fired at will, my lord. I was hired and fired at will
Where is
of the
where
employer.
is your firing letter?
There was no order also, my lord. There was no order. And in a number of cases, even Supreme Court has decided that a contractual employee cannot be arbitrarily dismissed without inquiry or without a so-called notice.
Enquiry? What enquiry? Is there any allegation against you?
No, my lord. But I was performing my duty diligently.
No,
I have a
I
right
mean,
to be informed.
Is there any allegations against you? Is it
No, my lord.
case that there was something happened and because of that you have been terminated? It is not your case. Your case is only that you have been appointed by an order of the authority wherein you have been taken as a contractual employee. Then your term of service was extended from time to time, and then they have stopped you.
My lord, at this says I have a limited prayer. That my representation dated 19/5/2026 may be disposed of. So, my lord.
Lordship, I don't have objection for that to dispose of that. Okay, we'll dispose of this petition with a direction to dispose of your representation.
Yes, my lord.
Okay. I heard, Mr. Your name?
I'm Padmini Chau, my lord.
So the learned counsel appearing for the petitioner also heard, Mr.
Assembly, Lordship.
For respondent numbers?
For the state, Lordship.
For the state?
Lordship.
For the state respondents. The instant writ petition has been filed by the petitioner challenging his termination from the post of lecturer in mechanical engineering at Khelhuse Polytechnic, ATOU, without issuance of any show cause notice and or holding any departmental inquiry in gross violation of the principles of natural justice. The petitioner's case is that he was initially appointed as lecturer in mechanical engineering in Kelhose Polytechnic, Tizo, under the Department of Higher and Education, Higher and Technical Education, Government of Nagaland, on the contractual basis with effect from 1/4/2014 against a vacancy caused due to resignation of Sri Solesul Rote, lecturer, mechanical engineering, Kolhose Polytechnic, Atiozu, with effect from 1/11/2023. Then you write, accordingly, the petitioner has joined duties on 1/4/2024 and was continuously discharging his duties with utmost sincerity and dedication. The petitioner's contractual engagement was extended time to time every year, and the last extension was granted by an order dated 17/3/2023. It is the case of the petitioner that after the last extension, you work till which date? After your last extension on 17/3. 17/3. Where is your last? 17/3.
March 2023.
17 March 2003 for 1 year.
For 1 year I have served.
For 1 year.
Yeah. But my post was
1 second, 1 second. 17/3/2023. Accordingly, he served in the department till 17/4.
Yes, ma'am.
17/3/2024.
Yes, madam.
He served in the department till 17/3/2024. Full stop. However, without giving any intimation or intimation of any termination, the service, the engagement of the petitioner was not extended by the respondent authorities. In view of the aforesaid, the petitioner has submitted a representation to the Director, Department of Higher and Technical Education, Nagaland, on which date?
On 19 May 2026.
On 19/5/2026. Full stop. He submits to 6. It is the case of the petitioner that his representation has not been considered by the respondent authorities, and he has not received any information or response to the aforesaid representation. Full stop. The learned counsel appearing for the petitioner submits that he is only praying for a limited. He has come before this court only for a limited prayer. That since he has already submitted his representation and his service was terminated without any termination notice or any other communication, his representation should be considered by the respondent authorities by way of a speaking order. Full stop. The Mr. So-and-so, the learned counsel appearing for the government, doesn't have any objection to the prayer made by the learned counsel appearing for the petitioner. Taking into account the aforesaid, this court is of the considered opinion that the instant writ petition can be disposed of with a direction to the respondent authorities, namely the Director, Department of Higher and Technical Education, or what?
Yes, madam. Yes, higher technical
education, Nagaland, Kohima, to consider the representation dated 19/5/2026 submitted by the petitioner and dispose of the same within a period of 1 month from today by way of a speaking order.
And my lord, if it please, my short submission may be recorded that I was initially appointed as a lecturer in
as a lecturer in medical engineering, and I was again re-employed.
I've stated so. I've stated that you have been appointed, then you have been regularly extended.
I was transferred to another post as a lecturer in automobile engineering.
It is not required. I mean, those things are not required. Every details is not required to be made. I mean, this will suffice. You have submitted submitted a representation. Let them, reply to that with a speaking order. Okay.
Yes, my lord.
They will give you a speaking order. Then you write after passing of the order. After passing of the order, the concerned director, concerned director of after passing of the order, the director of Department of Higher and Technical Education shall provide a copy of the speaking order to the petitioner.
Right, my lord.
Promotion item number 26.
Yes.
Is it please, my lord?
Hmm?
The petitioner here is aggrieved by the assessment report dated 3/3/2026.
So tell me one thing, in the assessment order, in the joint inspection, you were there. You were a party to that. During the joint inspection, you were there. You were a party to that. And after in the joint inspection, they have come to an amount after calculating. Now you are saying that that was not correct. How you can go on and go on?
But my lord, at a
See, there was a court's direction. You have alleged that during the construction of the road, certain portion of your building has been damaged, and your art is also damaged. The court has taken the cognizance of the matter, and court has passed an order asking for a joint verification and spot verification, whatever, including all the stakeholders. Then they have stakeholders, including you. Then there was an assessment done. In the assessment, they have come to a finding, and they come to a conclusion that there may be a damage of 10 lakhs of rupees or whatever. Now you are a party to that. Now after that, again you have come to the court saying that no, that this was not taken into account. This was not my price is this much, market value is this much. How can it can go on and go on?
my lord, the assessment report is unfair because the amount I've invested and the cost of the land at the prevailing market rate is way below.
Do you think that the amount you have invested and the house market value will be taken now? Will not be any depreciation value of your building? If will not be depreciated at the price of your building today, you have built a building. The building has become old. There is a calculation and methodology how depreciation is calculated. And after that, they have arrived and you have not objected to that at that point of time. You are a party to that.
I was party to that, but the assessment it is carried out by the department. I was only present at the spot verification. It was beyond my control to bring out the estimated amount. And my lord, my humble prayer is that my representation may be disposed of because
the problem is that now you are not happy with that. Then again there will be a joint inspection. Then again he will say that I am not happy with this. Then again he will come to the court. Again court will. Is this the way to it will go on like this?
No, my lord. Honestly speaking, after this reassessment, I'll not
No,
be.
in the reassessment, see spot verification, you were there, correct? You were there during the spot verification. All these people are involved, and they have come to a finding. Where is their assessment? But this looks to be an old house. And their the house, price of a building will depreciate.
An extra 4 pages from page 20 to page
22.
On page 22.
The RCC building so and so. Annual depreciation they have calculated. When did you build the house?
In the early 2000.
Yes, council, you are paying for whom? State.
State Lordship.
Who is the concerned party, NSIDCL or you?
It's us, state.
What is your
Lordship, the assessment have been done to go over again and again. Lordship, after you have stated.
But he's saying that that assessment has been done by you. I mean, with as per your calculation, and he's saying that that market value of the building has gone up. I mean, that place, that you have not taken into account the market value.
Building.
Assessment is already done. There is no requirement of any assessment.
My lord, it's not only about the building, it's about the land also, my lord.
Land, what damage land has
Land
done?
was also cut off.
The assessment is
Substantial-
already done. I mean, they have
Yeah, but-
joint verification one was done. You were there. So what more you want?
The assessment is low,
See,
it's unfair.
joint verification means what is the damage caused, right? And you are saying that like land part was not taken into account. Is it so? The damage on the land has not been taken
Yes,
into
my lord,
account.
yes, my lord.
They are saying.
Yes, my lord. At the present market value is around 8 to 9 lakhs. The cost of the land.
They have not
The
acquired
portion
land.
Of the land, but it was damaged, my lord.
Damage mean what kind of damage?
The land was, I cannot use the land anymore.
Huh?
The land was already damaged. The portion
Damage
of the land.
means like whether it has been taken away or art
Yeah.
was cut or what?
It is cut, it is taken away.
I can't see anywhere that the land has been cut away, taken away. You have not stated anything about the land. You have only stated that land value is estimated at so and so.
My lord, in para 6 of my petition.
Para 6 Act, that's what I'm reading. What have you stated? Therefore, as it does not reflect the actual structural damage caused to the building and the damage to the developed land. What developed land? What damage has been caused? And how you have calculated this 8 lakhs to 9 lakhs rupees? On what basis?
As a prevailing market rate in the area, the plot are sold.
Has your land been taken away by them?
Beg pardon, my lord.
Has your land been taken away by them?
Of course, my lord. The building situated in the land, and along with the building, some portion of land.
So they have
also-
taken away your land.
Of course, my lord.
What is he submitting? They have taken your land. Land was acquired from you.
It was not acquired, but it was damaged by the
What
accident.
damage? That I'm asking. What damage? Have you given any photograph? What damage has been caused? Simply saying so, and you have calculated 8 lakhs of rupees. On what basis you have calculated 8 lakhs of rupees? You give a basis of the calculation.
My lord, in this case, the notice may be issued and I may be allowed to
No,
bring
not
additional
I mean, each and every case, you don't have right to write a notice to be issued. You'll have to convince the court that you have a case. You simply come up with that my land has been damaged. You have not written anything what damage has been caused. Land was not acquired from you.
Then was
If
like,
land had the land been acquired, then obviously like you would have got a good case. But your land was not acquired. And secondly, the damage, what damage has caused, you are unable to explain what damage has been caused.
my lord, in the
And whatever the assessment was done only on the buildings, and at that time we did not object to that. You had a party of one of the person who was there in the joint verification. Why didn't you raise that objection that time? My land is also damaged. You have to pay me for this also. Have you raised any objection at that time? Now joint verification has been done. An exercise has been done by the parties. Now you are again coming and saying that like no, I mean this thing has to be done also. Cannot we go on like this? Okay, he has some allegations about road land damage and all. So you hear him and dispose of. I'll pass the order. I'll dispose of this petition because he has submitted an application before you. You dispose of the application.
Lordship.
Because his allegation is that the land has been damaged.
Lordship.
And damaged land has not been considered.
Lordship.
This is one contention, and second is also that value of the house is less.
Lordship.
Because the market value has not been taken into consideration. That is his contention. We are disposing of this with the direction. Okay.
Yes,
Otherwise, I would have dismissed it. But since you dismiss it.
No, my lord.
Okay, you try your luck there. Okay.
Yes, ma'am.
Heard Mr. So-and-so, the learned counsel appearing for the petition. Also heard Mr. So-and-so, the state counsel representing the state respondents. The instant application under Article 226 of the Constitution of India has been filed by the petitioner contending assailing the wrong assessment order, assailing the assessment order for damage to his residence as well as land. Land by the respondent authorities while constructing what? While constructing the two lane
Construction of Akwego,
the construction of while constructing Akwego Avanku section of National Highway 202K. The case of the petitioner is that the petitioner owns a residential building along the highway at main town Wejiho. It is contended that after the construction of two-lane national highway two-lane national highway 202K Akhego Des Avanku section in Meludi district, has caused damages to the developed land of the petitioner as well as the RCC building standing on the aforesaid land. It is contended that that due to such damage to the residential house as well as the land of the petitioner had submitted a written complaint on 4/5/2025 before the Deputy Commissioner, Meluri, to carry out a spot verification and assessment of the damaged property, and thereafter pay the compensation for such damages caused to his property. Full stop. However, the aforesaid complaint representation was not considered by the respondent authorities, and therefore he was forced to approach this court by way of filing WPC number 6/2026, wherein this court, by order dated 23/1/2026, directed the respondent authorities to carry out a joint verification and assessment of the petitioner's damaged residential building. See, there was no direction of any land damage or whatever. There was nothing. There was no direction from this court when the matter was disposed of about your land assessment or that was not raised probably before this court. Now, if you come up with new things, then it cannot be done.
It's more about department have to take into account.
See,
The land also.
it says that carrying out necessary residence only for the verification of the residential building and assess the damage. It doesn't speak about the land. Now you have come up with a new plea.
Normally, when buildings are damaged.
No, buildings are damaged. Land is not accounted to. Building is damaged. A building is damaged. Well, how the land will be damaged?
Lord, the then so taken into
You
account.
have raised that issue earlier. Now you are diverted from raising that issue. There was no direction from the court to do the assessment of any damaged land. Then again, you will be dissatisfied with the observation of the department, and again you will come to the court.
No, my lord.
That I've been wasting the court's time. Pursuant to the aforesaid order, a joint verification was conducted by the district administration, NHIDCL officials, authority engineers, Mayasil Construction JSP Private Limited, PWD Housing officials, representative of the executive agency, representative of the executing agency, village authorities, and the petitioner, was carried out on 20/2/2026 and on 3/3/2026 respectively, and the calculation of the depreciating value of the building as per SOR NPWD 2021. Thereafter, an assessment report dated 3/3/2026 was prepared, assessing the damage, the estimated compensation amount for rupees 10,85,911 only. The case of the petitioner is that the assessment and the compensation calculated by the respondent authorities is very less in comparison to the loss that has been the comparison to the damage that has been caused to the residential house and the land owned by the petitioner. it is contended that damage to the land has not been taken into account while assessing the damage by the respondent authorities. In view of the aforesaid, the petitioner has submitted a representation dated 5/5/2026 before the Deputy Commissioner Melody, requesting for a fresh reassessment of the damaged residential building of the petitioner as well as the land. The same has not been responded by the respondent authorities as yet. Have you received any money till now?
No, my lord.
The learned counsel appearing for the petitioner submits that the assessment has been wrongly done by the respondent authorities, and respondent authorities, additionally, no assessment of the damage of the land has been done by the respondent authorities. In view of the aforesaid, he submits that since he has already filed a representation before the respondent authorities, the same should be considered by the respondent authorities. He submits that the instant repetition can be disposed of with a direction to the respondent authorities to consider his representation dated
5/5/26.
representation dated 2026 submitted before the Deputy Commissioner Melody Nagaland. Full stop. Mr. So-and-so, the learned counsel appearing for the respondent authorities, does not have any objection to such limited prayer of the petitioner. Full stop. Taking into account the interfacts of the case and submissions made by the counsel appearing for the respective parties, this court disposes of the instant petition with a direction to the Deputy Commissioner to consider the representation filed by the respondent by the petitioner 5/5/2026 and pass a necessary speaking order within a period of 1 month from today. Next paragraph. While considering the representation of the petitioner, the Deputy Commissioner shall also include the other stakeholders involved in the incident case before passing the speaking order. In view of the aforesaid direction, the instant repetition is disposed of. You submit you submit the order, then you write a line before disposal. You write the petitioner to submit a copy of the order to the respondent authorities at the earliest. You submit a certificate copy for them. Then only they will take some action, otherwise they will not. So within 1 month, time has been given. So as soon as possible, you submit that certified copy to them, respondent authorities. You are there, you can intimate them also. Consider he's saying that the land is also been damaged, but somehow maybe in the direction the land was not mentioned. But since he's raising some issues, we'll do it.
Lordship.
For admission, item number 3. Item number 3.
None appeared when the matter was called for. Let the matter be listed after 3 weeks.
For admission, item number 5.
My lord, I appear for Power Grid Corporation of India Limited. My lord would recollect this is the matter with regards to relocation
Yes,
of the tower.
yes. What happened now?
My lord had asked us to file an affidavit, and we have filed an affidavit. I believe it's placed before my lord. By way of this affidavit, we have brought the minutes of the meeting dated 31/7/2026.
1 second, when did you file it?
My lord, it was filed today morning itself.
Today morning.
My lord.
Where is that? Where is that affidavit?
Item number 5.
Who is appearing? The local council? You are?
Lordship, Lordship.
Power Grid?
No.
For the state.
Power Grid, who is appearing? Any local
My lord,
council?
my lord, my colleague is there. I just saw him going out. He's gone to the registry to check. Yeah, he's there. Mr. Ed Zimumi is there.
Okay, it is not on record. Yes, yes.
My lord. So, my lord, you can come down to page 7, annexure 1.
Yes.
My lord, we can come down to the third last paragraph, which is of material. May I, my lord? After detailed discussions, it was agreed that a new tower number 151 will be constructed and the existing tower number 151 will be dismantled with direct stringing between tower number 151 and tower number 153 to avert potential power supply disruptions to Mokokchung and adjoining districts. Existing tower number 152 shall be dismantled as there are safety risks. The proposed realignment follows the existing corridor with minor deviations and meets all technical and safety clearances as per the applicable laws. Further, it was agreed that Power Grid team in coordination with district administration will initiate due process for ground assessment in respect of new alignment. Accordingly, new tower will be erected in due consultation with landowner concerned in accordance with existing legal provisions.
So how much time you will require for this?
My lord, the new route alignment will be taken, my lord. These are technical things. My lord, before I address my lord's query, there is one thing which we would like to place for purpose of record, my lord, that this tower is not being shifted because the landowner at location number 152 wanted, because it will send a wrong message, my lord. We are shifting because of the unchecked querying activities. The tower has become a hazard. It's become a serious risk, my lord. If any issue and inadvertence happens with the tower, it can lead to a loss of life also, my lord. If somebody, I hope I'm being able to communicate or place forth, my lord, the concern. So this shifting may not become as a precedent for anybody wanting to get it shifted, making use of this situation. That is why our technical assessment has said that no, the tower 152, as of now, is hazardous, is a risk, my lord, because of the mining activities, how aggravated they have become until where they have come. Now, if my lord would like to look at those photographs in my previous affidavit, my lord will find those photographs also of the whole query site, my lord, as to actually what has happened, my lord, and how we have reached where we have reached. My lord, we filed one additional affidavit, 23/3/2026, the previous affidavit.
23/3.
My lord, in the month of March, my lord, we had filed one additional affidavit. My lord, this affidavit was filed in light of order dated 17/3/2026.
There is one affidavit which was filed on 20th April. And
my lord, the cost title would read, affidavit was filed in terms of order dated 17/3, 10/2/26 and 17/3/26, my lord. In view of these two orders, we filed one affidavit.
Yes, yes.
My lord, if my lord has found the affidavit and my lord could travel down to page 30, in fact 29, my lord.
So I mean, this adjacent land is owned by the petitioner. Where
My lord,
mining is happening?
my lord, page 30 will show that this is where the mining has taken place. Now the mining, my lord, page 31 will show that the mining came from far north side and it traveled towards our tower. Page 31 will give the clear illustration.
Now this land is owned by whom? The petitioner.
My
Where
lord,
the
the
mining
query,
activity is going on?
the mining activity below is that of the petitioner. That is what is said. So my lord, what I'm trying to only show is that the tower is at risk. And this is the reason why we are shifting it into
No,
the
we
new
understand
alignment.
that, but we understand that when we are saying that like this land is owned by whom? You.
Lordship, prior to the installation of the tower, the coring activities has been carried out by my fathers, and then that is our livelihood. And then, Lordship, the whole stretch, it's accessed prior to the installation of this tower. So the power grid cannot say that the whole picture belongs to the petitioner land, because it belongs to different person.
My lord, be as it may, we are in the process of now shifting the tower. We have decided with the district administration, our technical surveys are done. Now, my lord, with this inclement weather and my lord, we'll have to erect a new tower. One temporary structure strut will have to come so that the transmission cannot break. Once the new tower, my lord, to construct this tower, there has to be proper pile foundations, concreting will happen and then the tower will go up. So my lord, it will take some time, my lord. If the matter can come up after 8 weeks, my lord, we'll be able to place forth.
Lordship, my friend, he is submitting on the allegation.
He's submitting on the allegation. He's saying that the power grid has taken a decision to dismantle it.
Right, Lordship.
He's going to dismantle it, and because this is a public utility.
Lordship, I agree with that, Lordship.
Correct. So public utility, so that they are dismantling it. But like thing is that for this assessment, because otherwise they cannot just dismantle it just like that. They'll have to do some assessment.
Lordship, I appreciate with that.
All these things. So he's seeking for some time for that.
Lordship, let me have a short submission on this. Lordship, this exercise was taken by the respondent authorities on the indifference of this honorable court by 26/3/2026. Or otherwise, they were having on the very stern allegation that the petitioner is disturbing their tower. Whereas this honorable court, after hearing the allegation and our submission, it has come to the conclusion that the private property, the petitioner land, is not within the purview of this right of way, or neither they have not acquired my land. Thereby, this honorable court has rightly observed and passed an order that the respondent authority, more particularly the deputy commissioner, has no authority to issue the restraining order. Now, after the observation and then the passing of the order, the respondent, they are taking initiation and then coming to the conclusion, to the final that they are going to shift. And then that shifting has been already stated in the previous meeting, because this matter is pending for quite some time, now almost three years. Now in the previous meeting, they have already decided to allocate even the contract order to the person contractor for shifting of that. But despite of all this, they are keep on pending, tracking on that. Now, when this honorable court has passed an order on 26th, on that they have taken the steps. And then now, after a lapse of 4 months, they have now come to a final conclusion that they are shifting this tower to other location. So my humble submission is that
they are dismantling it and like other 2 towers.
Yes. So now, if they are coming to that final decision of shifting, my humble submission is that, see, they should keep a specific time, because it cannot go on like this, asking for attendant delay.
That is the reason, when
Lordship.
When last week we took the matter,
Right, Lordship.
We have strictly told them, like, you file an affidavit.
Right,
Lordship. You have taken. Correct.
Yeah, it's lordship.
We have understood the gravity of the matter, and that's why we have asked them to file
Exactly.
affidavit as at the earliest.
Lordship.
Now, thing is that they have filed an affidavit.
Right,
That,
lordship.
so I'm just asking them how much time they will take.
And then
Now,
lordship.
they are saying 6 weeks. Now, the court has to find out whether 6 weeks. I mean, a court doesn't have any way to find out whether it will take 6 weeks time or it will take 4 weeks time. Correct, because
Lordship.
this is something which is to be done. Do with this public utilities. At one disruption, I mean, the electricity will be off. The many people will suffer. So now the reasonable time has to be given to them. What do you suggest?
Lordship,
I don't have any expertise to say that this much of time, you take this much of time and finish it off.
Lordship,
That
on my presumption, dismantling of that tower, it will not take time.
But realignment and other things will require. That is the thing. That is the thing they are talking.
And then, lordship, since this respondent has returned me, and because of that, now I'm giving restraining my livelihood for more than 3 years. So there should not be in order delay. And then on the last,
Mr. Khera, how much time will take? You give a commitment. Because see, the thing is that coordinate bench has already come to a conclusion that the order of the DC is incorrect. First of all, there should not have been any restraint order. Now, problem is that this is a public utility. Public utility thing, which is required to be dismantled or taken to a different place. So that is why we are concerned. But thing is that like he is before this court, and he's agitating before this court for last 3 years, and he's saying that like, his livelihood is hampered, and the order of the district commissioners is already this thing. So how much time will take?
My lord, on an outer limit, we will complete the exercise within 6 months.
No, within 4 months you complete it.
My lord.
Within 4 months.
lordship,
We'll endeavor for 4 months. My lord, we'll
let
endeavor.
it be 3 months, lordship. Let it be
The
3 months.
My lord, if I may, my
3
lord,
months.
it's an inclement weather going on. There are
No, how much time? How much time you are seeking for? 4 months.
4 months, my lord.
The 4 months will be too much. 3 months, within 3 months you'll do it.
My lord.
Then we'll release the matter again.
Lordship, on the last this hearing of this by this honorable court, the endeavor was made to dispose of this matter.
So I can dispose of the matter with a direction to complete the exercise within 3 months. If
Lordship,
you
lordship.
My lord, let the matter be. My lord, let the matter be pending.
Why? That means that you are going to complete it.
My lord, we will endeavor every aspect to complete it, but with the inclement weather and the rains, my lord,
3 months is
in that
3 months will go to today. Now it's the month of August, September, October, November.
Yes, lordship.
So there won't be any rain also that point of time. So 3 months is sufficient. I am disposing of this matter with a direction to complete the exercise within 3 months. Anything else is required?
Lordship, my humble prayer is that since now the court is going to dispose of this matter, let this impugn order be set aside.
That was already this thing, no?
No, it is not. It has till now.
My lord, till my shifting does not happen. My lord, till my shifting does not
issued by the deputy commissioner
happen, they cannot do any mining activities, my lord. In fact, they are barred by law. Under Central Electricity Regulatory Authority guidelines, my lord, section 67(3), as it is.
Page 66. Page 66.
So, my lord, once I shift the tower, that restraining order itself goes away. But if they do the mining,
so it has to be closed. Because of that only I'm stopped.
Let my brother give an undertaking. 1 minute, let me submit. If my brother gives an undertaking, if he does mining and there is any loss to life or human property which happens, will they be responsible? So, my lord,
my friend, that is irrelevant. Irrelevant. My friend, that is irrelevant. What undertaking I will take? So sorry. Don't submit irrelevant submission.
To do mining today. Court is asking me to shift the tower, giving me an outer limit of 3 months, my lord. We will endeavor our best to shift the tower, and once it is shifted, they can do their mining activities if they wish to. That is between
what he is saying that like within this 3 months.
No, he is making compulsion to undertake. What is this, lordship?
His intention was to
this
say
is practicality, my lord.
Wait for a minute, Mr. Khera. His intention was to say that in these 3 months you should not do anything.
Till now, I'm restrained, Lordship.
Till now you are restrained.
Yes,
So the
Lordship.
restraint order will continue till the completion of the work, till 3 months. After it, after their this thing, once the tower is
It means the case will remain still pending, Lordship.
disposed of with,
Then when the
with-
case is
with-
disposed,
with only condition that you will not do anything till the tower is dismantled, because this is, I mean, if you do certain things.
Okay, Lordship, if I go with that, I agree. But what will happen with this restraining order if it is not set aside?
I mean, the restraint order, we'll see what is to be done with that. The restraint order was already, I think.
No, it is still exists.
Where is the order?
26.
Page?
Page 66 in my petition. 66, annexure 6.
66.
And then this is my grievances, Lordship. And now your this honorable court is going to close this case.
One second.
Page 66. Annexure 6. This is the restraining order.
Page 66.
Yes, of my petition. Annexure 6. This is the restraining order issued.
This is counter.
And then type copy is at page 67, Lordship.
Page 67.
Yes, this is the type copy.
This is correct, but like, we cannot vacate this order as of now, because till the time he dismantles it, this restraint order will stay. Because otherwise, I mean, if you start doing something there, and tomorrow the tower falls, and what will happen?
Then in lieu of that, Lord,
you'll have to give some kind of undertaking.
Lordship, in lieu of that, let me have a humble submission before the honorable court that if they are taking, giving assurance to shift the tower within 3 months, let the matter be listed on that day. Let the matter be listed again on that after the completion of 3 months.
That's what he's saying. But like, I don't think there is any point, I mean, keeping this matter also.
No, because see, before this grievances on, I'm coming before the central court because of this order only.
Yeah, correct. But like, we are saying that like restraint order.
And then, and Lordship, the honorable court has directly pointed out that on 26/3/26, this.
Then we'll keep it pending. I mean, we are not getting this restraining order as of now. But like, let them complete, then only court will see. We cannot vacate the restraining order today itself, because this.
Then suppose, Lordship, if
there will be a problem of.
Yes, understood.
Understand, right?
Yeah, understood.
So what the court is basically asking is that till this tower is dismantled,
Lordship.
because that is why the restraint order was passed.
Lordship.
Looking into public
Lordship.
issues, right?
Lordship.
Now till this 3 months, till they are saying that within 3 months they are going to dismantle it. For at least 3 months, the restraint order will stay.
Lordship, I'll go by that. But if the case is closed, my humble submission, if the case is closed,
We'll not close this case.
Okay, Lordship.
I will not close this case. We'll just mention that additional affidavit has been filed.
Lordship.
And on the basis of the additional affidavit, the court is directing that court is giving them time for 3 months, and within 3 months they are supposed to they will dismantle it, and after dismantling it, they will file an affidavit before this court. The matter will be listed after 3 months.
Lordship, and then Lordship, my humble submission before the court is that since long back they are keeping asking time on time several times.
No, we are strictly giving them 3 months time.
So let they should complete that exercise within.
We are giving them only 3 months time,
Lordship.
And we are asking them to file an affidavit after dismantling the tower.
Lordship.
Correct. Once it is dismantled, then your problems will go. Then you can do whatever you want to do. I mean, as per the law. If law allows you to do co-query, then I mean you can do it on or whatever. I mean, like it's as per the law. If you can do it on your own land.
Lord, my lord.
Correct.
On behalf of the state respondents, if I may be given a chance to speak.
Yes.
In my affidavit in opposition, which was filed before this honorable court on 20th April 2026. On receipt of the complaint letter written by the Power Grid Corporation on 2nd May 2023. This restraining order issued by the Deputy Commissioner was in the interest of public, for the safety of the public.
Correct, understood.
And so far, series of meetings have been held. The Deputy Commissioner Bogokchong has made every endeavors.
No, now what do you want? Now what do you want?
To solve this problem, series of meeting.
No, what do you want now?
My humble submission before this honorable court is that time and again, affidavit after affidavits, by way of filing additional affidavits, concrete resolution has to come up.
So they are saying that within 3 months they are going to dismantle it.
If within a period of 3 months, no concrete decision is arrived at.
No, you what do you want?
My lord.
You want it to be dismantled or you want it to be to remain like that?
Both the parties. We are for the safety of both the sides.
Correct. That's what I'm asking. Now, see, there was a solution you'll have to find.
Yes.
Because this is a public is involved in a lot of things. And we'll have to see his concern also.
Yes.
Because he's private land.
Yes.
There was a restraint order. The court has come to a finding that he doesn't have any authority to do it.
I have.
But still, listen, but in spite of that, the restraint order is still there.
Yes, ma'am.
Correct. Restraint order is still there. So now only thing is that like now they have come up with a proposal that they are going to dismantle it within 3 months. And you know that like because it's a like high powered line and there are a lot of villages and surrounding areas are being given electricity through those towers only. If it is disrupted, then it will be again a public disorder kind of thing. I mean, like for 1 day, 2 days, fine, but it will take some time. Correct. I mean, they'll have to do some technical assessment and all these things. So they are asking 3 months time. He is agreeable to 3 months time.
Yes.
And I mean, we are giving them 3 months time to do it.
My lord, my humble submission before this honorable court is this restraining order is not issued at the whims and caprice of the Deputy Commissioner, Bogokchong, on the strength of the complaint letter written by
we
the
understood that, like that you need not read.
We are for the safety of the public.
We understand that. I mean, why Deputy Commissioner has passed, we understand that.
Yes.
He has taken into consideration the position, time, and like facts at that point of time. And
Yes.
accordingly to that, what was the good thing to do, he has done it. We are not saying anything. But only thing is that like whether he has done it as per the law.
Petitioner is trying to shift the responsibility on the part of the Deputy Commissioner, whereas the Power Grid Corporation, they are also trying to shift the responsibility here and there. So
No,
for
my
the
lord, we are
administration-
now all in sync. In fact, my lord, we are
See,
grateful.
Power Grid Corporation
We are
also is
grateful
state
to state,
utility.
my lord, it is the state which has led to us, which has led us, and we have followed the state. My lord, we are grateful to this state and the district administration of Mukokchung, especially the Deputy Commissioner, Mr. Ajit Verma, an IAS officer, and his team. In fact, my lord, this resolution which we have reached to now, my lord will see my affidavit which I have filed today, page 8. This resolution which we have reached to, the tower is not safe and it has to be shifted, is a joint decision which has been arrived at by Power Grid and the Deputy Commissioner, my lord. My lord, page 8 will make it clear.
Yes, on the part of the district administrations,
Yes.
we are
So we are
putting
grateful to the district
every
administration.
effort to solve this issue.
And, my lord, I would take this opportunity to also say that the district administration of Mukokchung is one of the most efficient that we have come across in
Thank
helping, assisting, and guiding and leading us to come to this stage where, my lord, now we are attaining this thing. And I'm very thankful to my learned additional advocate general brother also there.
Okay,
For
I'll
leading
just
us
come back in. I'll just come back in 5 minutes and then pass the order. Just 5 minutes.
My lord.
Fine, okay, that's the question. Station? Api, the question. Dega. This post. This post.
Right. Heard your name, Mr.
S. Timjan, Lordship.
Huh?
S. Timjan.
Heard Mr. Swayanso, the London Council appearing for the petitioner. Also heard LT Santam, the London Additional AG.
Yes, ma'am.
Additional AG for the state of Nagaland for respondent numbers 1 to 5. And as well as Mr. Khera, Mr.
My
Nitin
lord.
Khera,
My
Nitin
lord.
Khera appearing for respondent number
6, my lord, Power Grid, assisted by Mr.
respondent
6 and
number
7.
6.
6 and 7.
Respondent number 6 and 7.
Assisted by Mr. Dimomi, my lord.
Are you a senior counsel?
No, my lord.
Along with Mr.
H. Zimomi.
Okay. The petitioner has approached this court by filing the instant petition to issue a restraining order dated 18/5/2023. In the restraining order issued by the Office of the Deputy Commissioner, Mukokchung, respondent number 3, it is entirely mentioned that a complaint was received from the office of the respondent number 6 and 7 on 25/2023, to the effect that a landowner was carrying out stone quarrying activity near tower location 152 of 220 kV double circuit Mariani Mokokchung transmission line in CTC area, as a result of which the tower has become critical and prone to collapse. Next paragraph. The aforesaid restraining order has been passed taking into account the criticality of the tower, and the respondent number 3 had directed the landowner to refrain from carrying out stone quarrying activity near the said location till further direction. Then a notice was issued to the respective parties on 29/25/9/2025. Wide its order dated 17/3/2026. A coordinate bench of this court now by this order dated 56/2026, a coordinate bench of this court directed the respondent number 6 and 7 to take effective steps with the Deputy Commissioner, Mukokchung, and other authorities so that the tower in question can be shifted, or in alternative, may initiate action under the Indian Telegraph Act 1885 for acquisition of the right of way over the land of the petitioner. Full stop. This court-wide order dated 3/8/2026 on the basis of the submission made by the council appearing for the respondent number 6 and 7 that a process of resolving the issue has been going on, and the Power Grid Corporation of India, Deputy Commissioner of Mukokchung, and other officials of the Power Grid Corporation had a meeting on 31st July 2026 to resolve the issue, directed the counsel for the respondent number 6 and 7 to file an affidavit bringing on record the minutes of meeting held on 31st July 2026. In terms of the aforesaid order, an additional affidavit has been filed by the respondent number 6 and 7. 6 and 7. On perusal of the additional affidavit, it is seen that after a detailed deliberations, the district administration and the officials of the Power Grid Corporation of India Limited agreed that the existing tower number 152 shall be dismantled as it is a safety risk. Full stop. It is also seen that they have decided it has been decided that a new tower number 151 will be constructed, the existing tower number 151 will be dismantled with direct stringing between the newly constructed tower number 151 and tower number 153 to avert potential power supply disruptions to Mokokchung and the adjoining district. The proposed direct stringing follows the already existing corridor with a minor deviation and meets all technical and safety clearances as per the applicable law. It is also mentioned that the team of Power Grid Corporation, in coordination with the district administration, shall initiate the due process for ground assessment in respect of the new alignment, and accordingly, a new tower will be erected in due consultation with the landowner concerned in accordance with the existing legal provision. The learned counsel, appearing for respondent number 6 and 7, has referred to the minutes of meeting held on 31st July 2026, which has been brought on record by way of filing this affidavit in opposition. And he submits that the whole process may require about 6 months' time, full stop. 6 months' time to complete, full stop. Therefore, he prays that 6 months' time should be allowed to the respondent number 6 and 7 to complete the whole process of dismantling tower number 152 and replacing tower number 151 and with the realignment to tower number 153. Full stop. The learned counsel, appearing for the petition, however, objects to such prayer of 6 months' time for completion of the whole process. He submits that his livelihood is suffered because of the restraint order passed by the Deputy Commissioner. Full stop. The learned additional AZ, appearing for the state respondents, has submitted that the district administration is also cooperating with the Power Grid Corporation for the dismantling for the resolution of the whole issue, and shall support the Power Grid Corporation of their activities for dismantling and realigning of the towers. Full stop. Taking into view the submissions made by the learned counsel appearing for the parties, this court is of the considered opinion that 3 months' time should be granted to the Power Grid Corporation to carry out the dismantling and realignment activities in terms of the minutes of meeting dated 31st July 2026. Accordingly, it is directed that on completion of such dismantling within 3 months that has been granted by this order, the respondent number 6 and 7 don't write respondent number 6 and 7, write Power Grid Corporation shall file an affidavit bringing on record the completion of the whole exercise. Full stop. Let the matter be listed after 3 months.
Lordship, a specific date may be given for
After 3 months.
after 3 months. So Lordship, if 3 months it completes.
Once it is 3 months is over, the matter is
Yes.
not listed, you can mention the matter. You can mention for listing the matter.
Because as I said, the matter is dragging on by asking
Now,
several
we have-
extension.
Now we have directed them to complete it in 3 months. Other than that, what this court can do?
Lordship,
This
Lordship.
court cannot do anything.
Let the matter be listed right after the completion of 3 months in that
Okay,
case.
let the matter be listed. That's what I have written. Let the matter be listed after 3 months.
Right after the completion of the 3 months. My humble submission.
Okay, let the matter be listed after completion of 3 months. Okay?
Right after Lordship.
Right after completion of the 3 months.
Lordship.
Immediately after completion of 3 months. Okay? That will do? Fine?
We can list it on 16th of November. My brother, I think.
16th of November. Okay.
Yeah.
Lordship.
Okay, let the matter be listed on 16th of November.
Lordship.
Give a specific.
Another 3 months, Lordship. Okay. Another 3 months extension, Lordship.
Yes, that has to be. All these are public utilities. The court has to look into all the things. And DC has passed the order taking into account the position. I mean,
The Lordship.
Situation at that point of time.
On the last occasion, I have submitted that before the Supreme Court, the landowners are ready to give the land also, provided if you wanted to acquire.
No, that's what now.
But now they have changed their.
Now in the minutes they have written about, so they will discuss with you about acquisition also if required. Is it not, Mr. Khada?
No, Lordship, we have.
My lord,
If required,
my lord,
will be consulted and he will acquire the land also if required.
My lord, if required, but my lord, we don't acquire the land. We are exempted under law from acquiring land. We only take the right of a user.
Right of the user, correct. Not acquirement, correct. Right of the user.
Right of
Under
use.
Telegraph Act, whatever is available under Telegraph Act, they will do it.
Yes, Lordship.
But with the my lord, my lord, in maximum of our discussions, my lord, we endeavored our best to ensure that the tower is where it is. Because it's a very cumbersome process, my lord, of realignment and everything. But the technical team is, my lord, we cannot go against the technical team. They said
correct, that is why we have given you 3 months time.
My lord,
Okay,
we will endeavor to finish it. We should finish it, my lord, within this.
3 months time should be sufficient.
Lordship.
Should be.
Yes.
Should be.
Yes.
Highly obliged, my lord.
For orders, item number 18.
May I please, Your Lordship? Lordship, this IA is for amendment of the petition.
Amendment of the petition.
Yes, my lord. I want to insert some new paragraphs as well as some additional prayers and also implead one new respondent, my lord.
You should office then what is your
Lordship, I have served copies.
You are appearing.
Correspondent 7. Correspondent 7.
I have served copies to the state. That is respondent number 1 to 6 and respondent number 7 also and respondent number 8 also CGC. However, my lord, respondent number 9 and 10 Mr. YP Gupta appears for the railway, but we could not serve him a copy.
Then you have to issue a notice to them.
Lordship, then if I may be allowed to serve a copy to him because he has already appeared in this case.
You serve him a copy.
Okay.
There is no bar in that.
Lordship.
You serve him a copy if he's appearing in the main petition.
Yes, my lord. He has already appeared in the main writ petition.
Serve him a copy.
Lordship, and in the meantime.
We are not going to do a pass any order without the council. So we'll you serve the copy, then we'll post it. How much time will it take for serving the copies?
Lordship, I can within a week, my lord.
Within a week, then after 2 weeks, matter will be listed. Then we'll consider about your amendment. Because we'll have to hear the parties because you are making substantial changes into the petition. You are bringing in new paragraphs. You are bringing in new prayer and a new party also. So it has to be heard.
Yes.
Okay, heard MS so and so the learning. Your name, please.
Miss Lucino.
V. Cugino.
Lucino.
Okay. The learned counsel appealing for the petitioner also heard.
Lordship, if I may be given the opportunity to file objection, it's so advised.
Okay, let the notice be completed first. Heard so and so the learned counsel appearing for
Respondent 7.
respondent number 7 and
For 1 to 6.
learned AZ. So sanctum the learned AZ for Rasuna 1 to 6.
Yes.
1 to 6 and yourself.
What information?
Eighth. Union is respondent
Okay,
number
eight.
eight.
Mr. So-and-so, the learned CGC for respondent number 8, full stop. None appeared for respondent number 9 and 10. The learned counsels are appearing for the petitioner submits that she should be allowed to serve copies to respondent, serve copies to the learned counsel. Learned counsel appearing in the connected, appearing in the read petition. W petition number 129. 129.
For respondent number 9 and 10.
129, 129 of 2026, 2025,
2025.
2025, and therefore she prays a week's time, full stop. Our prayer is allowed. The prayer is allowed. The learned counsel is permitted. Learned counsel for the petitioner is permitted to serve copies on the counsel appearing for respondent number 9 and 10, full stop. Let the matter be listed in the after a week. Okay.
Lordship, in the meantime, there is an interim in the main writ petition. So if
the interim order, then you don't write it here. Then in the writ petition you write interim order so past earlier shall continue till the next date of listing.
For orders from the supplementary cost list, item number 27.
May I please, Lordship?
I have for what?
My lord, I have for extension of period, my lord. In the last occasion, I was directed to produce the instruction, my lord. The lordship, may kindly allow me to read the instruction, my lord. Kindly allow me to read it.
Yes.
The reason as to why the case of petitioners were not submitted to MRC, my lord, in Para 1. The office memorandum dated 17/3/2015, all work charge employees who have completed 30 years of service as to be cleared by the PNAR, Finance Department, MRC, and the Cabinet to be eligible for regularization. Accordingly, the present petitioners, along with the similar situated employees, were cleared by the Finance on 26/2/2026. Para 2. As per Office Memorandum 17/3/2015, Rule 1 Clause 3, the existing scheme for regularization of work charge employees against normal vacancy is being modified, and the quota for work charge employees stands enhanced from 50% to 67% for the next 5 years, effective from 01/01/2015. These existing schemes will also be applicable for the casual employees appointed on full-time basis. Para 3. The different pages for regularization were forwarded to MRC. However, the MRC turned down the proposal with the direction to comply with Rule 1 Clause 3 of Office Memorandum 2015. The department deemed it necessary to comply Rule 1 Clause 3 Office Memorandum 2015 before any proposal are sent to MRC. Accordingly, seniority lists were prepared and all vacant sanction posts were forwarded to PNR for verification and clearance. White file number so dated 29/4/2026. It may be stated that once the file is cleared by the PNR, the case of the petitioner along with the similar situated employees will be submitted to MRC. It may be stated that the case of the petitioners are not related to Rule 1 Clause 3 of Office Memorandum 2015. However, to partial compliance of the rule.
What partial compliance you want now? You are yourself saying that this is not applicable related to the simple.
Partial compliance means, my lord, actually out of 100% vacancy.
No, that is for the future thing.
Yes, 50 should be reserved for the.
That is for the future. That is for the future.
Workers, yes. So, however, due to partial compliance of the rule and having been given a clear direction that no further page of work charge employees will be recommended unless the department comply with Rule 1 Clause 3 of Office Memorandum 2015. In view of the reason stated above, the case of the petitioners along with the similar situated employees have not been submitted to MRC.
So you have not submitted.
This is the reason, my lord. Already submitted, but it was turned down.
Now you are not submitting it. Why are you not submitting it?
So, my lord, now
whether you can bring in all these issues when there was a court order.
No, my lord.
Then?
court has given direction. In that time, the file was already under process.
Correct.
It was
So,
processed
so,
in the
so
department.
it was under the process. Now you are taking a U-turn. You're saying that like at one time you are saying that like case of the petitioners are not related to 1-3. That means what? Then why are you not submitting it? You are saying that
Yes,
these
madam.
cases, petitioner's case is not related to this.
My lord,
This OM 15.
Yes.
But if OM 15 is not applicable to them, then what is the need of compliance with OM 15 in their cases?
My lord, in that OM 15, it clearly says that out of 100%.
Yeah, you are yourself saying that this is not applicable to them. It may be stated that the case of the petitioners are not related to Rule 1.3 of OM 20115. However, due to partial compliance of rule, what is this partial compliance rule? And having been given a clear direction that no further batch of work charge employees will be recommended unless department comply with Rule 1.3 of so and so. What is this? You are saying that like these petitioners are not connected. Then again, you are saying that unless this is complied with, what is this?
My lord, this is the direction given by the MRC because of this reason it was turned down. My lord, my humble submission is because of this reason the petitioner case would not be submitted before the MRC. Once it is cleared, my lord, it is under
Once cleared, you'll have to put it before the MRC. You have not put it before the MRC
yes,
now.
my lord. Now under process examining, my lord, to clear to rectify the discrepancies, my lord. So once it is rectified, it will be released before the MRC, my lord. It will be forwarded. So, my lord, my humble submission is extension were given to the state respondent to comply the order, my lord. Another 6 months sufficient time granted to the respondent.
Earlier, you have sought for 4 months. Now you are seeking for 6 months.
No, my lord, in the petition, it's already.
No, what is this?
No, my lord, it's already in the IA. It clearly says that we're seeking for 6 months. IA in the IA, it means in the 6 months.
But in the submission, you have made 4 months.
No, my lord, I have not made message. I have made only. I've got for 6 months, my lord. It is the petitioner who has suggested, my lord.
No.
So, my lord,
But this is not any reason. This is not any reason. So 50% to 67% they have enhanced
Yes.
quota for the
Yes.
next 5 years, effective from 1/1/2015. This scheme is not related to them. How you can take recourse of this scheme? London Government Advocate submits that there are 4 stages, namely so and so, complies so and so.
Your lordship, may kindly see page number 10 in the instruction which are placed before you. Annex C. This is the meeting minutes forwarded by the MRC, my lord. Page number 10. It was the petitioner case is under process from the year 2022, my lord. And this is in the last paragraph, my lord. In the first paragraph, I am directed to append here with the meeting minutes of the meeting on manpower regionalization committee, MRC held on 2 March 2022 at so in the secretariat. In the last paragraph, the committee directed the department to re-examine the proposal under the provision of the PNR dated 17/5/2015 and examine if any of these work charge employees can be accommodated under 50% as provided for under the Rule 1 Clause 3 of the Office Memorandum. Department may.
So now this order was passed in 4th March 2022.
Yes.
Till now, what you are doing?
it was forwarded. Actually,
No, till now, what are you doing? This was the minutes. They are saying that like
Yes.
department shall resubmit after examination. You cannot do the re-examination till date.
no, my lord. After that, again, it was submitted. It was turned down, my lord.
Where?
In the last letter, your lordship, the last letter turned down page number 12, my lord.
Huh?
2025, December 5.
This was 2022, 4th March.
Your lord.
Then
Thereafter,
this was December 2025.
yes, my lord.
December 2025, what have you decided?
He also, since my lord, since the department has not complied the clause.
So then your problem.
Yes, that is why it was turned down.
Correct. So you have not complied with
My lord, we are under examination, my lord.
what examination? How much time will
We will rectify, my lord.
Which is the order updated 13/7/2023?
17/3/2025, my lord.
13/7/2023. Yes. It says committee examined clearances of 1 fitter. For the remaining post, the department is asked to re-examine whether the procedures are fulfilled in respect of work charge employees and resubmit. So from December, you have not done anything. That means. See, to 13 July, this order was passed.
Yes.
And because we have not complied with this order of 13th July 2023, they have rejected it. You have not resubmitted it. Where you have submitted it? I am directed to Minister of so and so. 18 supplementary posts of work charge employees so and so. The department has not complied with earlier directive MRC conveyed by 13/7/2023. 13/7/23, there was an order. (13/7) there is an order. 13/7 says, clearly says for remaining posts of department is asked to re-examine whether procedures were fulfilled in respect of all work charge employees and resubmit. So where is your resubmission after this? After this, we have resubmitted in 5th December. But we have not.
Your also mechanically para 4.
Para?
First letter.
Which first letter?
The first letter which I have submitted this morning.
The department deemed it necessary.
Yes.
Department deemed it necessary to comply rule so and so before any proposal are.
Accordingly, seniority lists were prepared and all vacant sanction posts were forwarded to PNAR for verification and clearance. White number, the letter on, it was submitted on 29/4/2026. It may be stated once the file
Will be submitted. You're saying will be submitted again. Then you're saying it may be stated that once the file is cleared by the PNR department, the case of the petitioners along with similar situated employees will be submitted to MRC.
Yes.
So who is PNR department? Who is appealing PNR department?
I'm for the PNR.
Then what is your instruction? PNR department, what is it?
PNR has given clearance in the, you'll also kindly see PNR has given clearance and the finance has given clearance. Now the file has to be forwarded before the MRC.
So why do you need 4
This
months?
is the reason. My lord, I have already stated that the department has not complied the rule 1.
You are coming back to that again. You are saying that you have yourself written that department deemed necessary to comply with rule 1(3) of OM so and so before any proposals are sent to MRC. Accordingly, seniority list was prepared and all vacant. That means you have complied with rule 1(3) for verification. File so and so. It may be that then you are saying that then you are saying that it has been cleared by PNR department and finance department. Then what stops you in submitting this before the MRC, before the MRC?
Well, this is the instruction I've received.
No, I mean, you're not understanding. See, you read these instructions. First para only you are saying accordingly, as per the office memorandum so and so, all workers employees who have completed 30 years of service has to be cleared by PNR department, finance department, MRC, and cabinet to be eligible for regularization. Correct?
Yes.
Accordingly, the present petitioners, along with similar situated employees, were cleared by the finance department on 26/2/2026. Finance has cleared it on 26/2026. That was stated in the extension application also.
Yes, my lord.
That's why court has asked you why you take 4 months time why you took 4 months of time to submit before the MRC. Then what is your reply? Your reply doesn't reflect anything. Then you said that OM says this and that this. Then different batches were for regularization was forwarded to so and so and turned down the proposal on so and so. This was turned down on when? MRC turned down when? When was it turned down?
Madam, letters letter has not been enclosed, ma'am. Letters.
No, in your IA, what have you stated? Then they said ki PNR notification dated 22/5/2025.
Yes, my lord.
What is the PNR notification? Where is that?
The notification in the compliance affidavit, my lord. Compliance affidavit, my lord.
Where is the compliance affidavit?
Page number 5, annexure A.
Page number 5.
Yes, my lord. Annexure A.
This we have seen other it was nothing to do with these employees.
Yes, ma'am.
Then you are going round and round.
So, my lord, this is the instruction what I have received. That
Instructions. You are a counsel.
Yes,
if you are getting some instruction which is confusing, you have a duty to ask them what kind of instructions you are giving.
Yes, they've said that that rule 1 clause 3 has not been complied. That is why the case is been.
Then you are saying in your this thing, you are saying that department, it is stated that the case of the petitioners are not related to 1/3. You take proper instruction. We'll list it in the next week. And go on. So, I mean, go on with this. Next week we are listing it.
Yes.
Parties are duly represented. Let the matter be. Parties are duly represented. The learned counsel appearing for learned government counsel appearing for the state respondent submits that though he has received some instructions from the Joint Secretary Government of Nagaland. There is some confusion in the instruction, and he seeks some time for some clarification for the clarification, and therefore prays that the matter may be listed in the next week. Let the matter be listed in the next week. You take this clarification.
Okay, ma'am.
They are saying that like it is not applicable to this thing. Then again they are saying that like you are saying that because of this it was not sent. Confusing.
Much obliged.
Item number 28.
Same order, madam.
Same order.
Bless you.
For hearing, item number 19.
May it please your lordship. This writ petition is for quashing and setting aside the order dated 13/5/2022 by which recovery was made from my leave gratuity and from my leave encashment and gratuity.
for excess payment made to me when during my period of discharge, Lordship. So, Lordship, before going into the petition, I would like to give a brief overview of the facts. Lordship, there are two events in this case where I was discharged 2 times. First was I was discharged twice, Lordship. So first I was discharged in the year 2010 and I was reinstated by this honorable court order in 2015. So during that period, when the Assam Rifles was deciding whether I was entitled to back wages or not, they had given a speaking order stating that notional pay fixation may be done on the basis of 7 CPC, Lordship, and arrears were paid to me. And I was reinstated and I was working, and in the year 2021, I was discharged again, and I proceeded on compulsory retirement. And during that period, I was informed that excess payment was made to me, and some amount of money was already deducted from my leave encashment and my gratuity. And further, I was directed to deposit.
What is your name?
The
The petitioner?
petitioner, Mualong, Lordship. Mualong. Lordship, if I may take your Lordship to the petition.
No, 1 second, 1 second.
It's 1 o'clock, so we can continue after the break.
Okay.
Please, Your Lordship. Lordship, the petitioner here is a Rifleman General Duty. I was appointed on 19th November 2000 as Rifleman GD in 42nd Assam Rifles. Lordship, Rifleman General Duty is a grade 3 employee of the Assam Rifles, Lordship. So after serving for about 9 years and a few months, I was first discharged by Annexure 1, which is dated 15th May 2010. On incurring 5 red ink entries, I was discharged as an incorrigible offender with effect from 15th May 2010, Lordship. So, being aggrieved, I approached this honorable court by filing WPC 3K of 2015, and it was disposed of by Annexure 2, order dated 29/7/2015. It was decided in my favor, and I was reinstated. The respondents were directed to reinstate me back into service, Lordship. And thereafter, I reported back to service on 19th September 2015 after my discharge. However, by Annexure 3, Lordship, page 18, the respondents had decided that my absence period, that is the period of illegal discharge, was to be considered as dies non, and I was not entitled to any back wages by this battalion routine order, Lordship.
But have you challenged this order to 13 December?
Yeah, yes, Lordship, I have challenged it.
Where?
In WPC 99 of 2026, Lordship.
Where is that? What is happening to that?
Lordship, I think it has been listed only 2 or 3 times after it was filed, after motion, Lordship.
Then it should be, this matter should be heard together with that.
Lordship, in my opinion, these two are not related.
Why? I mean, that will have a bearing on this. Because that, that speaking order 13/12/2029, that is the main order which has passed.
Lordship,
Because your contention of deduction and all this thing.
Either way, look at the cases release not be very There is another repetition getting proceeded now, so it's very clear.
It's better, it should be heard together. Why those two petitions should be the same facts, same these things?
Yes.
Lordship, but in this matter, I'm not aggrieved by the 13th December order. Because
Correct, but if 13 December order is set aside or upheld, then there will be some bearing on this matter.
Lordship.
Then,
Then in that case, Lordship.
let this matter be listed with this. I mean, it cannot be heard in isolation. I was just going through this order. Then I found it like, if you have order, challenge this order,
yes,
then that matter has to be heard together.
Lordship.
It will have the.
It will be better if this can be taken up together.
Yes.
Lordship, then in that case.
Okay, then you will put the matters together.
Lordship.
Your name?
Upang Menla Longchar.
Heard so the learned counsel for the petitioner also heard Mr. Yanavati, the learned CGC for all the respondents. The learned counsel appearing for the petitioner submits that another petition. Being repetition number?
WPC 99 of 2026.
2026 is pending before this court. Pending before this court. And pending before this court. Since both the cases are arising out of similar facts, and similar facts, both the matters should be heard together. Accordingly, let this matter be listed along with the WPC number so and so. When do you want?
After 3 weeks, because in the other case I can't find my affidavit.
You haven't filed affidavit. Okay, listed after 3 weeks.
Obliged, Lordship.
Because this case will have bearing on that.
Lordship.
This cannot be hard in isolation.
Lordship.
Yeah, because that 13/12 order, that is, if you have challenged that order will have some bearing on this.
Lordship.
Because of those things.
Obliged.